What are notwithstanding clauses and what's their purpose? A relatively common occurrence in California legislation, and then, of course, in statutes, is a bill that contains in the text of the measure a phrase something like, notwithstanding any other provision of law, or something similar. What exactly does this phrase mean, and why would it be used in a bill and ultimately a statute? Now, this type of a phrase is used regularly in contracts and in other legal documents, but what's the purpose in legislation? Well, first, what form can it take? If you look at California bills, you can see notwithstanding section, notwithstanding any other law, notwithstanding any other provision of law, notwithstanding any provisions of law, notwithstanding any provision of this section, notwithstanding any contrary provision, notwithstanding any other state law. So it obviously comes in many different forms. Secondly, what's the purpose of this phrase? Well, the general definition of notwithstanding is in spite of the fact that basically the phrase is used to say, hey, in spite of any other laws that might be contrary or that are found elsewhere, this new section of law that we're putting in, it takes precedence over the other ones. In other words, the phrase notwithstanding any other law is legal language that states what is following after this introductory clause notwithstanding supersedes any other law that might be applicable or that might contradict it. Now, as you might expect, this phrase can raise a legal question whether it really means that no other provision of law actually applies. The term or the phrase that begins with notwithstanding is actually commonly used in both federal and state legislation. So its use here in the state of California is not by any means unique. In fact, hundreds of bills in the US Congress, as well as the California legislature and many other states, utilize this phrase. So how do the courts interpret this provision? To be fair, federal and state courts sometimes accept it and sometimes they reject it. As you might expect, it really depends on the context in which the courts find this phrase as being used. Some courts have interpreted the phrase narrowly to only apply to conflicting laws. And then other courts have interpreted the phrase broadly to supersede all other laws. As you can probably imagine, similar to other matters of statutory interpretation, the courts may look to the surrounding statutes and the intent of the legislative body. The US Supreme Court in Cisneros versus Alpine Ridge Group, a 1993 decision, said the use of a notwithstanding clause signals the drafter's intention that the provisions of the notwithstanding section override conflicting provisions of any other section. So why is this phrase used? Well, sometimes bill drafters could either use this broad phrase or they could reference a specific code section or additional code sections in the use of the phrase. The specific section reference is to supersede that specific code section. When legislation or a statute uses the broader phrase, then it could be for several reasons. Maybe there are just too many other code section references that would need to be specified, or it may be too difficult or time consuming to list every reference. So we use the all-encompassing language instead. A bill drafter also may not want to miss any potential conflicting provision of existing law. And so they use this broader phrase to ensure that they capture all other potential provisions that might be applicable. At the same time, bill drafters need to be careful that use of this broad phrase doesn't somehow inadvertently exclude application of another statute that should in fact actually apply in the particular circumstance. So as a result, when drafting statutes that contain notwithstanding any other provision of law or similar language, be careful that such a broad outcome is actually desired.